Yeah.
Thank you.
Yeah, I was wondering
I didn't
too.
read anything about it. All I
a lot
read
of work.
it was just anti-suppression.
I had something, I don't know what it was, but he had.
Yes, and there,
Yeah.
yeah, it was.
I don't know, because he had something,
Clients.
something covered.
It's the power.
Something
There's a lot of
covered.
information and they won't put it.
Something else.
Yeah, yeah.
Yeah.
Oh, good, I love it. No, I picked it up and I was like, this is like gold.
Yeah, right.
I think it's
Good, good.
no, it's really useful, especially for those of us who do cases for record. And the link to the. Because sometimes our website is misleading. No, we don't know. It's not always just very involved, you get that same information. So.
Yeah, sure. Oh, good, I'm glad.
Okay, so you were the guys who decided that the ethics credits were worth coming out in the rain. Thank you for being here. This, you can come and sit. This is the last session of what has been a 6-session CLE on 1983 litigation. For those of us who are in this neighborhood of pro se litigation in the federal courts, putting on this kind of a CLE is really a big deal for a court to do. And as a member of the relatively new pro se litigation team here, I'm really grateful that this court not only was willing to put it on, but really embraced it. We expect to put on a series next year.
Can you talk into the mic, please?
I'm sorry, I thought
Thank you.
I was, okay. We hope to put on a series next year of probably more substantive topics in the civil rights area. So look for that next winter. Before we start this session, can you raise your hand if you have ever been in a prison facility, either as a visitor or a resident or an employee? Okay, a lot of people. Have you been in Wyatt or the ACI? Same people. More than once? Okay. How many of you have represented a prisoner? Few. How many of you have handled a civil rights case, civil case? Couple, okay. Well, we hope that having put on this CLE, we will in some ways start to expand the civil rights attorney presence in Rhode Island. We're going to talk in 2 parts today. First, Nicole DeLibero from the Department of Corrections, Jeff Peckham, who's a senior trial attorney at the Rhode Island Public Defender, and I'm Barbara Hurst, working for the court. We'll talk some about the kinds of cases that we get and the kinds of litigants who are involved in those cases that come in as pro se cases. Part of our function in the pro se team is to screen those cases to ensure that they state a plausible federal claim. And if they don't, we make a recommendation to the judge who's assigned to dismiss them. If they do, they simply proceed like any old civil case. On some of them, there are motions to appoint counsel, and even when there are not motions to appoint counsel, it's part of our job to decide whether we should recommend to the court that counsel be appointed. And that's where the pro bono panel comes in. The second part of the program will talk more pointedly about the pro bono panel from people who are either on it or who have handled these kinds of cases. We have two very different groups of litigants in the pro se cases that we get. And the pro se cases are nearly 20% of this court's active caseload, so they're a fair number. A little less than half of them are prisoner complaints, and that's one of the groups of litigants. The other group, who are non-prisoners, are now filing more of them than they used to, so they account for a little over half. The populations are very different, but they share certain characteristics. They lack financial resources, and most of them come in with a motion to proceed in forma pauperis. They also tend to lack a certain kind of world experience and world view. It's a little hard to describe, but let me give you an example. I was representing many years ago a client on death row, actually, in Rhode Island, and we were talking about the phenomenon of shared understanding among the authority figures in the criminal justice system, and shared understanding of police, judges, sort of implicit signals. And my colleague handling the case with me said, look at it this way. If the United States sent the Fifth Fleet into the Persian Gulf, it wouldn't have to call up Iran and say, we're watching you. That would be a pretty strong implicit signal. Absolutely no idea what Terry was talking about. Not just the Fifth Fleet, but probably the Persian Gulf as well. They have had a lot of experience with bureaucracies, not all of it pleasant. A lot of experience with institutions. By definition, the prisoner group has had a lot of experience with the criminal justice system, probably none to nearly none with the civil justice system.
Barbara, can I just one point? So I think what Barbara is saying, it's important to keep in mind that we're not talking about the intelligence level of the people that you might be representing. I think what she's trying to get at with this phrase world experience, it's the kind of thing that if you heard someone say, oh, the Fifth Fleet in the Persian Gulf, we would all get it, not because of our intelligence levels, but just because of the world experience that we have. The people that you're going to end up representing probably don't know about the Fifth Fleet, and they may not be able to locate Iran on a map. It doesn't mean that they're not intelligent. Yeah. And the other thing is, in terms of the kind of the niche folks that you might be encountering here, they do have a certain level of sophistication that you might be surprised with, because by definition, they're a pro se litigant who has gotten far enough that they've been screened into the next level of being accepted for potential review by a federal court. So that in and of itself is something. And so when you meet a new client, that person has actually done something that is somewhat unusual to get past that first step. So I would try to keep that in mind.
And not only have they navigated pretty far in a pretty foreign system to get to that point where we're talking about appointing counsel, they've gone to a lot of trouble to file a case. They tend to feel very, very wronged. There is this feeling that always sort of surprised me among my clientele, but I did criminal defense for decades, a very narrow group of people, which was a sense that wrongs ought to be remedied, and that there is someone somewhere who has the obligation to remedy that wrong. And it's a funny feeling to me about authority, because there's some suspicion of authority, but there is also what struck me as sort of a funny respect for authority and sometimes an overstatement of what authority can accomplish. There's also sometimes a real suspicion of counsel who are provided without cost to them. This you get what you pay for kind of thing. But also a real openness to being proven wrong, and in my experience, ultimately a huge amount of gratitude that comes from representing people for whom the state or the federal government or the volunteer lawyer community is providing voluntary assistance. There's also this, I found, real respect for education and respect for people who have degrees in higher education and titles.
No, I think that's true, and I think that it's sort of a double-edged sword with a lot of the clients that you meet, because a lot of them, you know, they've been sort of, the system hasn't treated them well. That's why they're filing 1983 actions in federal court, right? But they also recognize they need a little piece of the system to fix the thing that the rest of the system got wrong, and that's where all of you folks come in, right? You're the fixers.
All of you folks who decide to join the pro bono panel.
Part of the system, but a part of the system that the formerly pro se litigant needs to kind of rely on and trust, even if there's this general suspicion of the system.
Yeah. There's also, in the prisoner cases, pretty well-developed legal theories. They tend to be cases that are fact-intensive and are going to go down one way or up on the facts. Not the subject areas are a lot of Eighth Amendment excessive force, Eighth Amendment failure to protect, Eighth Amendment inadequate medical care, some due process complaints, some religious freedom complaints. But those are all areas in which the law is relatively well settled. They also, as we've said, have gone through a screening system. And by and large, it's the cases filed by non-prisoners that don't get through screening. Whether it's because the people out there have an entire world of people to sue, or they tend to be people who sue everybody from the president on down to their landlord, or whatever reason, or because there's a lot of expertise in the prison often about this particular cluster of causes of action. So we get some complaints that are really well written and that speak specifically. They'll check off the boxes of jurisdiction and where the claim comes from and who the proper defendants are. And sometimes they're getting help in the system, sometimes they're experienced themselves, and sometimes they're people who have a pretty high ability to write very anyway, Jeff can talk more about the particular population, but what I wanted to get across to you is that by the time we are looking for counsel, these cases have been screened not only to make sure they present a viable federal claim, but that they seem like the kind of case that will really benefit from counsel, where the plaintiff is anxious to have counsel. Sometimes really intriguing legal issues, and I think that the second group of people is going to give you a few examples of cases in which we've appointed lawyers recently, and also convey to you that when you take an appointment on the pro bono panel, if you would benefit from having a mentor attorney, we can do that, and the court is, in whatever ways it can express to you, very grateful that you do so. Jeff.
Thanks. Okay, so basically Barbara asked me to just sort of talk a little bit about what all of this means, like as it relates to the attorney-client relationship. So that's really going to be the focus of what I have to say. And I think And there were more hands in the room that were raised when the questions about you've been to a prison, represented an incarcerated client before than I expected. So I don't mean to speak down to anybody. If I'm saying things that everybody thinks is like, okay, well, that's obvious, I apologize. This was drafted as sort of not really knowing what everybody, what their experience levels were going to be. But I think the goal of an attorney-client relationship in the context of a criminal case, and I think the 1983 crossover is pretty accurate, you just have to meet the client where the client is. That is simple to say, but not as easy to do in practice. Because the other side of that is you have to manage the client's expectations about what is going to happen with the case. So meeting the client where they are and then managing the client's expectations throughout the pendency of the case, the skill and the attribute that is most important for a lawyer is listening. You have to listen. You have to listen to a client talk to learn where a client is coming from and what's important to that client and that client's perspective. And then you have to listen so that you know how to respond so that you can manage that particular client's expectations about that particular client's particular case. So everybody, we go to law school, we like to talk, we learn how to talk. Talking is great and we need to talk as lawyers, but the more important skill as a lawyer is listening. And listening to a client is where you can reach empathy with a client. You can't get to empathy if you don't listen. And there's a little cartoon that we're going to play about the difference between empathy and sympathy. And they might sound like they're synonyms or somewhere in the Venn diagram of each other, but they're actually very different things. If you try to be sympathetic with a client, it's probably not going to go so well, right? It's when you can really climb down in the hole with your client that you're going to be able to forge the kind of relationship that you need to forge to help your client accomplish their goals and manage the expectations along the way.
So what is empathy, and why is it very different than sympathy? Empathy fuels connection. Sympathy drives disconnection. Empathy, it's very interesting. Teresa Wiseman is a nursing scholar who studied professions, very diverse professions where empathy is relevant, and came up with 4 qualities of empathy. Perspective taking, the ability to take the perspective of another person or recognize their perspective as their truth. Staying out of judgment, not easy when you enjoy it as much as most of us do. Recognizing emotion in other people and then communicating that. Empathy is feeling with people. And to me, I always think of empathy as this kind of sacred space when someone's kind of in a deep hole and they shout out from the bottom and they say, I'm stuck, it's dark, I'm overwhelmed. And then we look and we say, hey, you can climb down. I know what it's like down here. And you're not alone. Sympathy is, ooh, it's bad, no. You want a sandwich? Empathy is a choice, and it's a vulnerable choice, because in order to connect with you, I have to connect with something in myself that knows that feeling. Rarely, if ever, does an empathic response begin with at least. And we do it all the time. Because you know what? Someone just shared something with us that's incredibly painful, and we're trying to silver lining it. I don't think that's a verb, but I'm using it as one. We're trying to put the silver lining around it. So, I had a miscarriage. Oh, at least you know you can get pregnant. I think my marriage is falling apart. At least you have a marriage. John's getting kicked out of school. At least Sarah is an A student. But one of the things we do sometimes in the face of very difficult conversations is we try to make things better. If I share something with you that's very difficult, I'd rather you say, I don't even know what to say right now, I'm just so glad you told me. Because the truth is, rarely can a response make something better. What makes something better is connection.
Okay, so that's the point, right? The connection is the point, not your response as a lawyer. the connections that you make with the client are what is going to forge the attorney-client relationship. And going the sympathy route, as we can maybe a little better imagine now, is not the way to go. One thing I would point out from the video that kind of riffs off what Barbara had said earlier, the point in the video where the speaker said that one part of empathy is recognizing that someone's perspective is their truth. My sense is a lot of the people that you may meet if you do this 1983 work, they have a certain perspective that might not align precisely with reality. Maybe some parts of it do, some parts of it don't. I'm not saying that they're delusional, but their perspective is just not necessarily exactly the way the world is. If you want to have a successful attorney-client relationship, your first job is to take that first step of empathy and recognize that, well, even though this person isn't completely realistic about what's happening, this perspective is their truth. And for me to help them solve their potential 1983 claim, I need to adopt that, and I need to empathize with them and not judge them and not try to fix what their perspective is, because you're not going to fix their perspective. You might be able to tweak it, and this is the goals management part. You might be able to help them understand exactly how this is going to play out and see it through to the end with them, but you're not going to just come in and suddenly change their perspective, okay? Especially, I think, with 1983 litigants. They are, for a variety of reasons, very far into this claim, and that's what Barbara was talking about before. They feel that the system has, they're really wronged. Whether that's accurate or not is a different question, but the fact that they feel that way is important, and you have to recognize that as their lawyer, or the attorney-client relationship isn't really going to work that well. Obviously, you know, we all know that first impressions, first meetings are very important, and that is where you can begin to try to empathize with your client. And, you know, the way that you do that, like, none of this is anything you learned in law school, right? This is just how you behave as a person. And so you do the things when you meet a new client for the first time that you would like to do with a non-client. Like, maybe you shake their hand if you're that kind of person. Maybe you, I don't know, tell a story, whatever it is. But you do the things that you do as a person to signal to the potential client that you're on their side and that you want to work with them, and you are willing to meet them where they are. You're not the lawyer there in the suit yapping away. You're there to listen to them, okay? This might sound a little judgy, but it's just one of my sort of pet peeves. Like, if you want to go and you want to meet a new client and you want to build a relationship and you're their lawyer, you should, like, dress like a lawyer. You know what I mean? Even if it's a Sunday afternoon and you're going to Wyatt or whatever, and you should, you know, act like a lawyer and have a business card, because that's what lawyers do. You'd be surprised how many of those little things, acting the part, looking the part, you gain the respect without even having to do much, because you're just treating that person like a lawyer would treat that person, like a paid lawyer would treat that person. So little things like that can really help. When you meet a client, especially for the first time, but whenever you meet a client, you always want to be aware of the actual physical surroundings, the space that you're in. There are different places to meet, and Nicole may talk a little bit more about this, but the state facilities in Cranston, there's an intake service center, there's a minimum security, there's a medium security, there's a maximum security, there's a high security building. They're all different buildings, and they all actually have surprisingly different rooms or spaces where attorneys meet their clients. And we just always want to be aware of the confidentiality aspects, not only because we have that ethical responsibility, but because if the client senses that you're taking their case seriously and being confidential about it, that is going to give you a lot of respect with the client, and they're going to see that you're, like, acting like a lawyer. So little things like that, just being aware of the degree of confidentiality when you communicate as it relates to the actual space you're in, I think is important. There is, you know, especially post-COVID, there's the opportunity to teleconference, and I think the federal court may have that. I know that some of the buildings at the state prison have that. Sometimes you need to teleconference, and sometimes you might get to a point with a client where, okay, you get it. It's okay. You just need to have a quick meeting. But just keep in mind that even in this post-COVID, post-Zoom world, you can't replicate the face-to-face dynamic on a screen or on the phone. And clients pick up on that because people pick up on that. And we all know the difference between doing something face-to-face and doing something either on the phone or on a screen. And as much as you can try to have those meetings be face-to-face, the better it is. I'm not saying don't ever do the teleconference type thing, but just keep that in mind. One thing I would also say specifically about not just managing expectations for how the case is going to play out, but managing time expectations for a client is very important. These 1983 actions, they take forever. It's a long process. It's usually most of the time going to be a client who's serving a long jail sentence, so time tracks differently for those kinds of folks. And being upfront from the beginning about how long the process is going to take and giving them sort of markers on a calendar as to where they can expect, in some kind of range where they can expect some kind of development. Just doing that at the very beginning of the relationship, I think you help manage their expectations by specifically managing the time expectations, and you can head off a lot of the problems that can come up between an attorney and a client in the relationship just by lack of communication or the sense that like, oh, nothing's been happening, or I haven't seen that girl in a month or 6 months, whatever it is. So there are things that you can do at the outset to sort of prevent those things from becoming problems down the road. In terms of paperwork and what clients want, generally speaking, especially if you've got a partially successful pro se litigant filing a federal 1983 action, that person is almost certainly going to want all the paperwork. And our job is to give them all the paperwork. And Nicole will explain a little bit about how that works in the state prisons, because there have been some changes recently about how to get discovery and other documents to incarcerated people. And it's sort of it's sort of more annoying than it used to be, but it's important to get all the paperwork that the client wants to the client. I just think about, like, if I was an incarcerated criminal defendant or incarcerated person on a 1983 action, and I was just asking my lawyer, like, can you just get me the discovery? And that wasn't forthcoming. I personally would just find that to be like so bad. I would just think, why can't I even just look at the stuff that I want to look at? So
you also have to be fairly patient about what sometimes is a request of you to have the documents again. Things get lost in the prison, not usually, in my opinion, by the carelessness of the prisoner. When people are transferred from facility to facility, things get lost. When they're transferred from cell to cell, things get lost. When a cell is tossed in a search, things get lost. It happens. We send out docket sheets to plaintiffs all the time, and often duplicates and triplicates. So that will happen, and be patient with that. And I can't stress enough how important it is that if they want to see all the paper, which they almost always do, that you give them all the paper. Time passes very slowly when you're incarcerated in a lot of respects. And there is the assumption that if they don't see what's going on, nothing is going on. And that's really frustrating.
yeah, what I would say is, like, if I have a client, like the average, a client who's been held or incarcerated for more than a year and a half, odds are better that I'm going to have to re-give that person the discovery, because after a year and a half in prison, it's prison, so nothing, not saying anything nefarious is necessarily is happening, but stuff happens in the prison and paperwork goes missing for countless reasons. And yeah, you gave it to him before, but sometimes you got to give it to him again. So, and maybe this is apparent, but the literacy level of clients is, well, why do they need the paperwork? Like, maybe they have difficulty reading. Well, yeah, they might have difficulty reading, but the client base that you're likely to see, again, these partially successful pro se 1983 litigants, probably going to be, on average, a much higher level of literacy than the general population would be at the prison. So you're giving it to them because they want to read it, and yeah, they can read it probably. Sending clients mail, Nicole may talk about this also. There are different requirements when you send legal mail to different prisons, so just be aware of those. And think about, how difficult is it just to send a client a very short letter updating them on something? I don't know. It's not that difficult. But for someone who's serving a long jail sentence, a letter, whether it's a letter from a lawyer or a letter from a friend or whatever, that letter may be like the only change in the dynamic trajectory of that incarcerated person's day is they get a letter from their lawyer. So just simple like communication via mail, it's not going to, it's certainly not better than face-to-face communication, but just short letters updating incarcerated clients on the status of their case can go a long way towards managing their expectations, which, and I'll footnote this here, is going to make your job a lot easier in the long run handling the case. The better relationship that you have with the client, the easier it's going to be for you to help them navigate what needs to be navigated. Just one thing about dealing with family members. Family members of clients, sometimes it's absolutely essential that you deal with the family members of a client, either because of the particularities of the case or the particularities of the client. Other times you're going to have family members who want to like intrude into the attorney-client relationship and it becomes like a disaster. And then lots of times it's just annoying and family members are just like a source of headaches. And why do I have to have this conversation with the family member that I can have with the client? And why is mom calling me 5 times a week to ask about this thing that I told her last week I'm not going to have an answer for 2 months? So my sort of default is to like, I have the client explain to me what to do with the family members. Because sometimes you have clients who are going to insist, no, you got to tell my father all of this. And then other times you're going to have clients who say, please don't ever talk to anybody about this, especially my brother, because I hate him and I haven't talked to him in 10 years. And I know he's calling your office, but I don't want you to say anything to him about my case. Even if it's stuff that's not like confidential, just sort of general stuff, you have clients who like have problems with their family members. And you can do a very quick, destructive, you can really do a bad thing with the attorney-client relationship if you just step in something you shouldn't be stepping in by having a conversation with the brother that the client didn't want. So just be sensitive about that and asking the client, who it's okay to talk to about the case at the beginning of the relationship is probably a good practice. Just one other thing, generally, I'm a male, obviously, and clients, Barbara and I were talking about this. I don't think it's a misread of an incarcerated population to say that probably clients are going to react with a little more level of confidence accepting with a male lawyer for the first time than a female or an other gendered lawyer. I can't help you with that if you're not a male, but what I can say is that in my experience, just being yourself and projecting sincerity and projecting confidence is the best thing that you can do. And most of the time, the clients who, I wish I had a male lawyer, are going to come around to having a lawyer who might not be a male. And I can say that in my experience as a public defender, as a state public defender, who've had a lot of conversations with female coworkers who are like, oh, this client doesn't like me. Eventually, if you work at it, you can get it to be where it needs to be. Not that you should have those additional hurdles in the first place, but we have to meet the clients where they are, and meeting the clients where they are sometimes involves these, not great worldviews that they might have.
I didn't particularly find that. I must say I found fairly a lot that clients expected me to care on some personal level. That may not have been a gender thing. That may have been that one of my practices was always with a new client to talk about just junk for a fairly significant period of time in a first meeting. Where'd you grow up? Where'd you go to school? Oh, is your sister in Rhode Island? I mean, just stuff. And some incarcerated people have very few visitors. They don't have a lot of people to talk to. And so simply being interested, I was at a settlement conference a few weeks ago in which we are appointing counsel, but the lawyer wasn't there at the settlement conference, and Jack McConnell was doing the settlement conference. It was an employment discrimination case with a pro se litigant who brought his mother and his wife, both of whom were very helpful being there. But Jack was just asking questions. And when it turned out the guy grew up in Warwick, Jack, of course, said, "Hey, I grew up in Warwick." And they spent the next 10 minutes talking about the ice cream stand that used to be wherever and going to Oakland Beach and whatever. And the I don't know, the appreciation on that plaintiff's face was palpable, that the court was interested. So anyway, that was my practice. So I never really found a real gender problem.
Yeah, no,
But other people may.
That may be the case. And I mean, what Barbara is saying is like, this is the thing. Like, you didn't learn any of this in law school, right? You're just meeting someone, figuring out how to connect with this person. And you're being who you are, and you're meeting a new person, and you're trying to engage with who they are. So.
Nicole?
I think I'm gonna get up so that I can see what I'm doing here. So if trying to develop a relationship with your client isn't enough, we at the Department of Corrections are gonna impose a whole lot of rules and things to make your life miserable. So I'm here today to hopefully give you some tips and pointers and understanding of some of the rules and requirements in coming into our facilities and meeting with people and getting documentation, to who you need to get it to and things like that. So hopefully, there's a lot in the slides, so I probably won't get it all, to you verbally, but there are copies and I think you have access to it afterwards. So hopefully the information is something you can refer back to and find useful if you find yourself needing to come to the correctional facilities. So I'm the Chief Legal Counsel at Department of Corrections and always available to help. Some of you know me already and know that I'm always willing to do what I can for you, so that's true for everyone here and whomever else you might know. So generally speaking, we have 6 adult correctional facilities. We have a facility institution and operations unit which oversees all of those facilities, and it's run by an assistant director who's referred to as the ADIO. Each facility administration also has a warden and 1 to 2 deputy wardens, which are in charge of the rules and regulations and operations of the facilities. Visitation generally at all facilities can be exercised by attorneys from 8:30 in the morning to 8:30 in the evening. And so we've got some sites on our website here for specific incarceration information about your client, like what facility they're in, information about visits and phone calls, as well as publicly available policies. You can find all of those on our website. This is just a quick little organizational chart for our institutions and operations, and as you said, see along the left side you have the 6 different facilities, and central office is where the assistant director is. The central office is also under the assistant director. It does more of our general operations, procedures and stuff, and then maintenance, food services, industries, and security. So that's basically an overview of the institutions and operations.
If you're going out to visit somebody, to see somebody, always do a last-minute check of where they are, because their facility may have changed, and they may not have been able to notify you.
That's true. So we have an intake service center. For those of you who don't already know, that's where your awaiting trial inmates are generally going to be. We will also have there some newly sentenced folks awaiting classification and movement to wherever it is that they may be spending their sentence. There's attorney-client visitation, contact visits allowed there. They have visiting rooms in the lower level, and you can also visit in the common areas. So the thing that in all of the facilities that's going to interfere with your showing up for a visit is always going to be the count times, which generally are 10:30 and 2:30. Well, at least at intake they're 10:30 and 2:30. Sometimes they're 10 and 3 at some of the other facilities. But as we go through, all the information's there, so if you need it, you can go back to it. Minimum security is going to be your work release inmates and those inmates with lower level offenses and mostly work release. Again, 10:30 and 3:15 are going to be their count times. You want to avoid that for visiting. They have visiting rooms and an office area, and they do allow the contact visits, which is great. Medium security, also contact visits, attorney rooms and visiting room, 10:30 and 3 o'clock. Maximum security, and medium security is going to be like your medium security level folks. There's a lot of programming going on in there, education and things like that. Maximum security is also allows the contact visits. They have visiting rooms and holding cells where you can meet with your clients. Their count times where they which will interfere with your visiting is 10:30, 3:30, and 5:30. High security is now more of a behavioral center. It houses our restorative housing program. It's no longer the traditional high security center that you expected or that you're used to. It does right now have non-contact visits, and there are there's some opportunity for contact visit, but it's generally not something that they prefer. You can show up to visit there as you can in the other facilities. Their count times 10:30 and 3:30, but high security actually prefers, if you can, for their benefit and yours, if you can call ahead and schedule a time, it's going to be a lot better for you, because they tend to have more of an opportunity for interference with the ability to show up and visit by the fact that what's happening in the facility, as well as their limitations on space. So if someone comes before you and there's no place for you to visit with your client, then you've got to wait. So calling ahead if you can is probably advisable. Women's facility is going to have both your awaiting trial female population as well as your sentence population. They have contact visits. They have a programming area which has some privacy built in, and their count times are 10:30 and 3:30. We have a bunch of different units that I think would be helpful to you. So Records and ID unit is all the sentencing folks, rehabilitative services and healthcare, some contact information there, and discharge planning for people who are on their way out. So discovery is something that you'll have to deal with quite a bit if you're handling these cases. We have a lot of things obviously available by way of discovery when you're talking about a case for claims of things that have occurred in the prison. We have commitment records, discipline records, grievance records, investigative reports. Obviously, you all imagine we have plenty of security footage, video footage, incident reports, statements, medical records, and so all of that stuff may or may not be part of whatever case it is that you're involved in, but all of it's accessible for discovery purposes. Medical records, just as a little aside, if you need them at some point during your case, not discovery-wise, you can always go to the site right there and grab the release, have it filled out by your client, and you can have access to those medical records, whether or not it's in discovery or at any other time.
Nicole, does the DOC always have medical records generated by outside institutions, like when prisoners go to Rhode Island Hospital? When they come back to the prison, do all the records from the hospital come with them?
Yes, so most of the times people will go for short periods of time. What comes back with them is typically their admittance paperwork and perhaps their discharge paperwork. And then the records are connected through the medical record system, so yes. Privileged mail, obviously, is what you're going to be sending in. So this is like a lot of information, but just to the general gist of it is that we now have enhanced procedures for accepting mail that comes in as legal mail or privileged mail. We have a scanning machine that is able to scan sealed envelopes, so there are requirements that the envelopes have only a certain number of paper, because the machine is able to detect abnormalities in the paper, which is sometimes contraband is soaked into the paper, which messes with the weight of it. So the scanning machine can identify by weight and by abnormality, like an X-ray type of thing, whether there's something, unusual about that paper. So your regular standard envelope needs to have 5 pages, your manila envelope needs to have 25 pages. And
Or less, you mean?
Yes, or less, yeah, preferably less. And just for a little tidbit of information, if you newly hand sanitized your hands, or you just put some hand lotion on your hands and you're touching the paper and putting it into the envelope, that little bit of hand sanitizer or hand lotion gets onto the paper and it will show up as an abnormality in the envelope. So once there's an abnormality in the envelope has to be held for further testing. The envelopes are never opened outside the presence of the attorney or you as the sender of that mail. Just as an aside, and I'll say this probably more than once, but to go back to Jeff's point about you may have to give the same thing more than once, the allowance for legal materials in cell is only 1 cubic foot, which is about the size of a milk crate. So legal materials, they're only able to keep what can fit in the size of a milk crate. So sometimes it's not because they lost it or because they couldn't keep it, but it's because maybe they have 5 cases and there's so much stuff that they had to swap it out for something else. So just keep that in mind. When you come in to visit, we also have some procedures in place now for papers that you're bringing with you. It's not that we think you're bringing drugs into the facility, but we just need to be extra careful. So if you come in with paperwork that you want to leave for your client, they will ask you to put it into a sealed envelope so that they can put it under the scanning machine before you bring it down to your visit. If it's clear, they'll hand it back to you and you'll be able to go down to the visit. So just keep that in mind when you're going in, because it's going to take a little extra time if you have paperwork that you want to leave. If you don't want to leave it, I don't think they're scanning it. So that should be all right. So electronic discovery is definitely something that we allow. So you can send in each facility, you can contact and you can send in a thumb drive or hard drive or whatever it is. And the offender is able to ask for, through a slip, to be able to review that when staffing and operations permit. So depositions can also be scheduled. There's a bunch of information here. You just start out by sending it over to the main legal mailbox, and then we'll get you hooked up with what facility you need, and they will then follow through with getting the deposition scheduled, whether it's a deposition of your client or you deposing someone else in your client's case. Law libraries available very regularly. Each of the facilities have their own scheduling, but they can ask for additional time by request. They have law clerks who can help. There's librarians. So there is some access to that, even if they are, even if the library is closed, there's a law cart that can go around. If they're in disciplinary confinement, they can still ask for the law cart. So there's a lot of opportunity for that. So, okay. So visiting is your usual, 8:30, bring your bar card, that's what's going to get you through the door. You have people that work for you, investigators, whoever, you need to get them scheduled as an attorney agent. That's super important. They're not going to be able to just walk in and visit like you would without being cleared on this attorney agent list. So that's something that you want to make sure you do for any paralegals or investigators or anybody that you want to say sponsor for being able to come in for visits. Your dress code rules, best advice I could give you is whatever you wouldn't wear to court, don't wear it to the prison. Shorts, obviously, flip-flops, tank tops, see-through clothing, like all that kind of stuff is pretty frowned upon. Anything, keep away with the metal, because obviously you've got to go through the metal detector, hats, things that can, hide things, where you can hide stuff, they definitely don't want that. So there's that's up in one of the facilities. I think that might be in intake, but so there's some just guidelines for that. I mean, I'm sure you're all pretty decent as far as getting dressed and being appropriate on that. But you can bring one bag with you, briefcase, pocketbook, handbook, whatever, handbag, whatever it is. and then they'll put that through the metal detector. If you have like a laptop or some other stuff that you need to bring for whatever reason, you do need to contact in advance to get approval for that. They won't let you just come through with a laptop. Cell phones are an absolute no-no. Smartwatches, anything that has Wi-Fi capability is definitely going to be something that they don't want you bringing. Filming and recording is absolutely prohibited as well. If there's a situation where you need to do something like take a photograph of your client, you need to call in advance to set something up like that as well. There's always issues in the prison all the time, so even though you show up for your visit and you think you're going to be able to do it, if there's a lockdown for whatever reason, they're going to turn you away. So please be patient for that. Phone calls, I think you're all probably pretty familiar with. All the information's there if you need it. Public defender's got a speed dial. You do need to get your phone numbers registered, as we do take cell phone numbers now as well, but they need to be vetted, so your phone number needs to be vetted so that it can be put onto the list as an attorney call, so that when your client calls you, your calls are not recorded. This is basically just what we do off in the legal office at the Department of Corrections. There are 4 attorneys, including myself. We're listed there, and the contact information for us is there also. And like I said in the beginning, we're always happy to help, so feel free to reach out if you need any help getting into the facilities or getting something to your clients or any problems that you might have.
Thank you.
All right? Yeah. So there we go.
Okay. Jennifer and Stephen and Josh, let's move on.
Thanks, guys. That was really great.
Now, do you want to?
Yeah.
Microphones.
Yep. Thanks.
All right, this.
You good? Hi, everyone. Can you hear this okay? Okay, great. We're going to introduce ourselves and then share some information with you about experiences really that we've each had, either bringing or defending cases in the federal court. And my name's Jen Wood. I've been on the committee that helped to organize this CLE, so you can send your hate mail to me. Actually, I'm really excited that you guys are the diehards. You made it here today. I think it's really valuable information. I'm particularly grateful to Nicole. That was a treasure trove of information about just basic logistics of dealing with representing someone who's incarcerated. I'm the director at the Rhode Island Center for Justice. I was sitting in the front row, so you all saw me pop my hand up in answer to every question about representing folks in incarcerated settings. Because actually, when I first came out of law school, I went to work at Rhode Island Legal Services. At that time, Legal Services Corporation did not restrict representation in class action matters or in representing incarcerated individuals. So I spent the next 10 years involved in the litigation relating to the conditions of confinement at the Rhode Island Training School for juvenile offenders. So I kind of grew up in the training school. I used to refer to myself jokingly as the longest serving person in the training school. Longer than most of the staff, honestly, because that case dragged on for over 30 years. I only had a piece of it. But as a consequence, that's something that I have some familiarity with, and we're going to talk about that today. Stephen?
Good afternoon, everyone. Can you hear me okay? My name is Stephen Richard. I'm an attorney at Nixon Peabody in Providence. We're a national law firm, and I've been a member of this federal bar now for 35 years. Every time I step into this courthouse, I view it as a privilege, and I try to take that same feeling into my cases, particularly when I'm against a pro se litigant or someone who has been appointed to represent a plaintiff. Most of my work is defense work, so at times I've tried to participate in the pro bono panel and take assignments, but have often been conflicted out. But I do think I have an obligation as a defense lawyer to look at the entirety of the program and to understand some of the dynamics that the first panel discussed, that one of the expectations of all the judges in this courthouse is that the lawyers will act with respect and collegiality. And it's very easy for me, representing institutional clients up against pro se litigants, to sort of have the David and Goliath approach to it and explaining to clients that, you know, we do have to be there, we do have to be accommodating. So one of the points that I want to make, and I'll talk about a little bit in my presentation, is the view of a defense lawyer, when dealing with either a pro se litigant or a court-appointed attorney through our program in the court, of how I interact with that counsel in a way that I think actually furthers justice, sometimes to the chagrin of my clients, but we can't lose sight of the big picture. So that'll be the focus of my talk, but I want to introduce my friend Josh as well.
Hi everyone, my name is Josh Xavier. I'm an attorney with Sinapi Law Associates. I graduated of Roger Williams Law School in 2014. So last year I celebrated my 10th year anniversary out of law school. Our law firm handles mostly employment law and constitutional law. In fact, one of the organizers of the entire seminar, Chloe Davis, heads up our civil rights practice and handles most, if not all, of our prison litigation. I haven't had the privilege and honor of serving on a case appointed by this court as pro bono counsel, but as a result of the seminar, I plan on joining that list. I personally have handled and am currently handling 1983 cases, and I've also handled a parole case on behalf of an inmate at the ACI. So thank you to all of you for expressing interest in pursuing 1983 actions and for joining the court's pro bono panel. And as Stephen mentioned, we're going to try our best to make a pitch as to why all of you should continue in this participation and advocate for pro se litigants and pursue 1983 actions. So thank you.
So Stephen, you're kicking us off.
Sure. So I wanted to build on my perspective as a defense lawyer, and probably about 10% of my caseload is defending against claims initially brought by pro se litigants. In a lot of them 1983 cases, and as we've heard, the litigants have vested rights. These are civil rights that are very important to them, and these cases do have merit. I can speak from the perspective of an attorney who lost a motion to dismiss to a pro se litigant about a month ago in a college case. I do a lot of work for colleges and universities, probably more so than any attorney in this state, representing both public and private institutions. And particularly in the next year to 2 years, we are going to see an explosion of cases that are arising from our college campuses and public school settings. What we're reading about in the papers on a daily basis with the fights for civil rights and what it means and what DEI means and doesn't mean will be hotbed issues for individual litigants going forward. For example, representing public schools, whether at the K through 12 level like I sometimes do, or colleges and universities as I often do, the free speech issues now are exploding on campus. The issues of the encampments that we all saw in the past year. What do they mean? What do they mean from the perspective of the encamping students? What do they mean from the perspective of the students who protested against the encampments? Some of those students have been disciplined by schools. Is that fair? So we're going to see more and more 1983 cases in that regard. And as I said, I've had the opportunity to receive a very privileged call from Judge Sullivan a couple of times saying, Stephen, can you take a case? My challenge is working in the firm that I do, we sometimes get conflicted out. But I know from experience, and I know Chief Judge McConnell often tells a story of a case that reached a trial in his courtroom where a very respected attorney, a friend of mine, Mike Daly, took on a pro bono case initially through the panel and represented a pro se litigant whose case made its way all the way to trial and actually prevailed in that trial and did a courtroom demonstration. I think it was some type of police brutality case where Mike and one of his colleagues were reenacting the scene on the floor in the courtroom. And to this day, it's left a lasting impression upon the court and the chief judge. So there's a lot of opportunity to make a real difference. Now, when I'm in the perspective of defending cases, and often starting with pro se litigants, or dealing with a case that could involve an appointed counsel through the court, I think I have a duty as a defense lawyer to further that case in a way that promotes justice. So little things that we've discussed today, the accommodations and civility that are expected of lawyers. If I know Josh is representing a 1983 plaintiff who is situated in Providence and has trouble with transportation, but can get to downtown Providence pretty easily through the RIP bus line, etc., I'm going to offer him space in my office. I'm going to be accommodating with time for extensions. And I'm going to try to facilitate the pursuit of justice in a way that makes this court proud, but also allows Josh and his client to present their case. Because from my perspective, the job is to defend the clean case that interprets the law properly and deals with the vexing issues as they arise. So we have an obligation as lawyers, particularly as defense lawyers, to understand the importance of this program, to understand the role that all appointed attorneys play in it. For those of you who are looking for this program as an opportunity to get experience, to work with a court, to work with a mentor, this is as good as it gets. And I mean this sincerely. I work in a law firm that has offices across the country, and people in my firm are fascinated when I tell them about the programs that go on through this court, such as the court-appointed process for pro se litigants, such as the Litigation Academy. There's a degree of interactivity that you don't get in most places in the United States. So I take that very seriously, and the opportunity to appear in court is a tremendous opportunity for you if you don't get into court as much, taking on one of these cases. You know, I've had the fortune of appearing in this court now for 35 years, but my most memorable experience, the one I am most proud of, is my very first case in this courthouse. And so that first case is also often your best case, and you build your career through helping people, taking opportunities such as this program, and hopefully having the opportunity to work with attorneys who will further the case on the defense side, cooperate with you interactively, and collectively make this court proud. This type of program is about us as lawyers making the community proud, making this court proud, and promoting justice. So I take it very seriously on the defense side. I think we're going to see a plethora of opportunities. I'm not going to get into a political debate about what's going on with all the EEOs, and right now they are being dealt with on a macro level, but let's not forget they filter down to people. And I can say that as a college and university attorney, that students are in desperate need of representation at this point. Students often are encountering issues with the administration at their school, trying to understand how all this plays out. Free speech, search and seizures, freedom of religion are all issues that are percolating on our campuses and in our schools. So please take advantage of this opportunity. You have a tremendous amount of people in this court behind it. I, as a defense lawyer, value this program, even though sometimes to my client's chagrin, it gives a case a much longer life and sometimes results in a decision that they may not think is as favorable as they could have had, perhaps if I litigated only against a pro se plaintiff. But I don't look at it that way. I look at it as our job to do to promote justice. So as a longstanding advocate of this court, please take advantage of every opportunity such as this one to participate in the program. And if you ever have any questions about what it means to take a case in this program and want to talk to a defense lawyer about the other side of it, look me up and I'd be happy to talk to you about it.
Thanks, Stephen. And raise hands for questions anywhere throughout our conversation, because it really is intended to be a conversation. Josh, you had some thoughts you wanted to share.
So, you know, when I was asked to join this particular panel and why folks should take on more pro bono cases and 1983 cases, for me, I think I took a step back and thought about our country and our laws and our rights. And for me, it's not every country in this world bestows on its citizens the rights that our country bestows on us. And not every country has a constitution or a democracy or a form of government that delineates what the government can do and what the government can't do. It's something that our country is proud of. It's in part as to why our country was founded. And it's something I'm proud of. And I assume that most of you, if not all of you, are proud of it also. Our country doesn't always live up to those rights, and our country doesn't always live up to those promises. But as a product of immigrants, folks who left their home country for this country, like many immigrants, our family story is that one reason why we left our native land is because our native land didn't have the rights that are enshrined in our Constitution and our Bill of Rights. And so the question becomes, well, why should we take on these 1983 cases? Well, in case you haven't noticed, when our government violates the Constitution, or when citizens or residents are denied their rights under the Bill of Rights, there isn't some magical constitutional angel that just comes down and just says, oh, time out, hold up, government, you violated the law, victim, your rights were violated, so here, victim, is an injunction against the government. Here is a pot of money to compensate you for your harm. That doesn't happen. There is no magic wand for the Constitution to enforce itself. We have to do that as attorneys. And for me, that's why I do what I do. Because every morning I get to wake up and I get to say, you know what? I get to enforce a document that makes our country great. I get to wake up every morning and advocate on behalf of individuals whose freedom of speech was violated, Fourth Amendment rights were violated, et cetera, et cetera. That makes me happy. I think it would make all of you happy too if you took on 1983 cases. So that's number one. Why do you take on a 1983 or pro bono case? Number one, because literally our Constitution depends upon all of us to play a role and to enforce these rights, because the Constitution is not self-executing, if you will. We need to actually file lawsuits and enforce them. I think for me, the second reason why I do what I do and take on these cases is I personally believe that if we were to measure our country and if we were to measure the standard of living in our country, I think the standard that we should be using is not how we treat the most powerful in our society. I think we should measure the worth of our country based upon how we treat the least powerful in our society, the people with the least amount of resources. That's how we should measure our society. And so when you see these violations, they often are against individuals with no money, no power, no connections, no network. And those are the individuals I think that we should be measuring how well we are doing as a society. And the best quote that I could find that actually kind of encapsulates it, it's actually not even an American citizen. It was Nelson Mandela who said, "A nation should not be judged by how it treats its highest citizens, but its lowest ones." Number three, finally, the third reason why I take on 1983 cases and pro bono cases is when victims of harm perpetuated by the government express gratitude to me, that thank you is actually the most sincere thank you I get from all of my clients. I am handling a case right now for someone who was falsely accused of a crime that they did not commit. And as a result of being accused, they were charged. And at the time of being charged, they were on probation for another matter. And because of the system in which we're in, he was deemed a probation violator, even though he was innocent of the crime that got himself charged. And so because he was a probation violator, boom, had to spend 10 days in prison for a crime he didn't do as a probation violator. And then at the end of the 10 days, when the judge set bail, $1,000 surety, so he had to, and my friend from the public defender's office can explain this better to you, but he only had to come up with 10%, $100. He didn't have $100. So instead of him only spending the 10 days in prison for being a probation violator, he ended up having to spend 20 additional days in prison for a crime he didn't do, for a total of 31 days. And it wasn't until someone in the community donated $100, that's when he was able to get out of prison. And so I'm litigating his case. I provide him with a draft of the complaint. I provide him a draft of the demand that we have made. And when I provide him with these documents, when he expresses his gratitude, it's like deep within. The deepest sense of gratitude I've ever gotten from any of my clients. Like, for him, this is a big deal. he was treated like nothing. Cops threw him in prison for a crime he didn't do. Probation violator, even though he didn't commit the crime. 20 more days in prison because he couldn't afford $100. And now I'm coming in, trying to vindicate his rights, and that sense of gratitude that he expressed to me is going to be with me for the rest of my life. And for those reasons, I would encourage you to get out there and start taking on these cases too.
Can I just add something building on what Josh said, in looking at it from the defense side, my clients, the public institutions or public officers, are public servants. And so on your side, you're pursuing justice to make sure that justice is served for your clients who deserve it. On my side, it's amending and fixing the system where it may be broken. And that's important for us to understand going forward, that sometimes cases can come to me where clients have embedded policies and procedures and practices and think that there's a qualified immunity defense because there's some uncertainty in the law. But as the case evolves, you start to see chinks in the system and something that needs to be fixed and something that needs to be corrected going forward. So there's a mitigation part of this that is important in the system, but it's also important for me as a defense attorney for public institutions to make sure that my clients don't lose perspective that they are public servants. And like you, the Constitution is what drives me and should drive all of my clients. And in the heat of litigation, you're often trying, of course, to win the case, but also trying to find solutions that make sense to fulfill the common interest both sides should have, is making sure that piece of paper that's under a lot of glass in the National Archives, that's faded parchment, still means something. So I think we share a common perspective just from two different sides, that we're trying to make sure that the system works for those who depend on it, but also those who implement the public service.
Yes, in the back.
I have a question, or maybe others are wondering it too. Does pro bono mean no payment ever? I know there's been, I think a carrot has been that you can get attorney's fees as part of 1983 suits. And I'm wondering what the reality of that is. And I think if a case settles, it sounds like one went to trial, so a lot of cases may have settled or been dismissed. I don't know if you can get fees if it settles, so I was just wondering if you could touch on that.
Very happy to address that, and actually that was part of my shtick because I'm the person on the panel that's taken cases through the pro bono panel and want to address that. But there was another question because I was going to get to that in a moment anyway.
Yeah, I guess I had two questions. One, I have always kind of conceptualized prisoner cases and conditions of confinement cases as like to me they fall into the bucket of kitchen table law because they are very intimate. They involve real immediate concerns that people have about their just their day-to-day experience in a really visceral way. And one of the in my kind of very limited experience within the world of legal aid, one thing that just comes through over and over and over again in dealing with the criminal justice system is the preservation of dignity, and that the grievances are also often really intertwined with a loss of dignity. And if you are, I think the first panel spoke very well to how, as the plaintiff's attorney, how critical it is to approach that thoughtfully. My question, and it's really a question for, it's a question for Stephen, for everyone on the panel, but if you are engaging as a defense attorney, what are the steps that you can take to ensure that you are preserving the dignity and respecting the dignity of the person who's on the other side of the table?
And that's a real important question, and it's very challenging on my side, managing my client's expectation, because they have a expectation that I'm going to be a zealous advocate. But how do you define zealous advocate, okay? Should I know the law? I hope I do. Will I be prepared? Yes. Will I anticipate what Josh will argue? And we've litigated against each other. I try to, not all the time. But what I also try to understand is that someone else on the other side really values this case. And, I'll give a more practical example on the type of work I do in college and university work, litigating cases that students bring, sometimes pro se, sometimes getting into trouble. My son went to college. And I always said to myself, how would I react as a parent if I got that phone call, right? That my son's in trouble or accused of something. And, I really take seriously the dignity part that you say, and it's something that's ingrained in my mind as someone who's been practicing maybe a little too long. I recall when I first started in this courthouse and in the state courthouse, and they may still have this, there used to be a little card on the table about the lawyer's duty of collegiality and respect, and I can't remember it. But, for me, the greatest honors are not only the cases I've won, but the cases that I've sometimes defended against. And in Rhode Island, there are 2 or 3 degrees of separation. You see people. And I've had plaintiffs come up to me and say, I didn't agree with what you did, but you always treated me with respect. And that to me is important because that's what I know the judges in this court expect. I know that's what justice depends upon. And what I try to understand is not only the legalities of the case, but what's really driving it. The example of the last panel where Chief Judge McConnell just talked to someone about their lives. I've lived in Cranston my whole life, grew up in Cranston. I know a lot of people in Cranston. And you can talk about the people and get to understand them and understand what drives them, what's important. And if I'm going to be pounding a table and destroying someone's dignity, I'm not going to be able to look myself in the mirror. And frankly, I don't think that is good lawyering. So I, as a defendant, have to manage my client's expectations, tell them this is what I do, how I do it, why I do it. I will know the law as best I can. I will brief it as well as I can. I will argue it as zealously as I can within the confines of a courtroom setting. But I've never, ever tried to lose sight of what drives the people on the other side because, frankly, I'm not doing my client a service if I put those blinders on. Because my clients think a lot of times we did nothing wrong, we should win this case, but I know my worthy opponent here has different perspectives, different views, and where it all lies and how we all sort it out. And remember, not many cases go to trial. So most of them sort themselves out through negotiation, understanding of perspectives, and coming to a solution that makes sense. So everything you raise is important. As a defense attorney, I view the best defense attorneys as those who understand exactly what you said, that there's a human side to it. And again, the best example I can give is just litigating hundreds of cases brought by college students that my son went to college, and I understand the perspectives of what the other side of the table is facing. And if I ever lose that perspective, then I don't think that I really want to continue with this much longer. So I hope that answered your question.
And I want to offer a yes and to that answer because what really is effective and what can help you make a difference for your client, whether you're defending cases, bringing cases, is the conditions on the ground are determinative in the last instance, always. I've done cases in New York and elsewhere, and the practice of law is different. Our discussion here today is about practicing in the federal district court in Rhode Island in 2025, because that experience was dramatically different in 1985 when I first started practicing in this courthouse. It is dramatically different in other jurisdictions, but that shouldn't matter to anyone in this room thinking about taking a case in this court in the next 18 months to 2 years. Because if you want to be effective, you have to know the judges, you have to know the culture, you have to know the conditions. And you will not succeed in winning motions and arguments and gaining extensions and gaining the advantage for your client to get a just outcome in a case in Rhode Island, in this tiny little environment, if you go around treating people without dignity. Because actually, then you're going to get that back. And a lot of the judicial officers do not appreciate that, do not respect that, and are not going to end up ruling in your favor when there's a close call. So just understanding there are a lot of good reasons that are intrinsic for everything that we're saying, but it also has to do with just being effective on behalf of your clients. Understand the environment in which you're litigating, and I choose to be here doing this work and have loved the career I've had practicing in this jurisdiction because I have seen it evolve from a very gendered and misogynist environment that I entered into as a young lawyer to a less gendered and misogynist environment in the current moment. And we're continuing to evolve. But the question arose as to, can you be successful in a career doing these cases from the plaintiff's side? And I'm going to read back to you the experience that I talked to every law student that I ever talked to about this, who was thinking about becoming a civil rights lawyer, bringing cases on behalf of those who feel their civil rights have been violated. In 1986 or so, when I was about a year out of law school, I went to a Northeastern Law School Alumni Association event at the Brown Faculty Club on the east side of Providence. And this very brash and forceful speaker named Barbara Hurst was the alumni speaker. And everyone was saying all the words about how we should all fulfill our duties as attorneys and do great things and be great crusaders. And Barbara, who was working in the PD's office, said, yeah, that's all really good, but guess what? You do not have to take a vow of poverty to be a plaintiff side lawyer or a PD and to do important and essential work to defend the Constitution, because it has been pointed out to me by many judges, judges cannot bring cases to uphold the civil rights statutes and the Constitution. Only we can do that. They can decide the cases the way we hope they will, but they can't bring the cases. And without counsel of goodwill bringing substantive defenses and arguments into the cases, we can't do our job well either. So that's why I really appreciate Stephen. But that's our job. And if you take an appointment on the pro bono panel, which I have done and which our firm does, you have a lot of opportunities there. The luckiest thing that ever happened to me was an older attorney coming into my office at Legal Services and saying, oh, we have this case at the training school, you know, it's just a little cleanup that needs to be done on the case. We already got the consent decree in place, but, you know, there's going to be a couple of cleanup motions, and you know, might need a motion for enforcement because things are kind of, you know, a little not going the right way. I didn't know what I didn't know. So I was like, oh, thank you very much. Oh, this is so interesting. And that became 10 years of my life and learning a whole body of law and, you know, just so many opportunities to learn from older, wiser attorneys, judges, court officials, and the young people I was representing who always know more about their case than you will ever know about their case. They know their case better than you can ever know it. So learning to listen and learning to represent people in those kinds of really complicated circumstances. And
Can you address the fees issue?
yes, so, and in that case, I later, through filing fee petitions, earned quite a bit of money because actually the state was, no offense, Nicole, and it was the juvenile system, doing a really bad job of operating that system. And so had to pay many fines and fees to the court and also had to pay a lot of attorney's fees because in those cases there is a fee shifting mechanism. You can, if you are the prevailing party and you vindicate important rights and you demonstrate that through litigation. So there's the litigation in chief, and then there can be the fee litigation, which sometimes is as challenging, more challenging or more hotly contested than the underlying litigation. There's an opportunity to be paid for your time on the basis of how much time you spent, how difficult it was, and what it would generally be worth in the community of practice. In addition, if you take a case through the pro bono panel, I mean, the reason it's pro bono is you're taking a huge risk. You may put hundreds of hours into the case and not be compensated. And that's why you have to be willing to do that. And it's some of the best work I've ever done. And it's taught me so much about how to be a good lawyer in other matters in which I have been paid on a fees basis. But in that context, you can also, there's a small fund for litigation costs. Because if you're in a small practice or if you're in a nonprofit justice center like we are, you don't just have tens of thousands of dollars lying around to hire expert witnesses and to undertake the costs of litigating complex claims. So there is a very, sadly too small, but I think under review to become larger, opportunity to access some small funds for litigation costs on behalf of pro se litigants if you do get appointed in a case. And that is non-trivial. It's very important to have access to that, and it should be used wisely. But what Barbara said that day was, these are real careers for serious people who can earn money and have an entire life doing this work. It's not just a hobby. It's not just something you do on the side where you have your day job and then you can take a couple of these cases. If you learn to do these cases and you get good at it, you get good at a lot of other things. You get collaterally better at practicing law, and then you can use that to build out a practice that is more varied. And you will know some of the most skilled attorneys in Rhode Island because they do this work, whether on the defense side or on the plaintiff side, and then you learn from them. So I see it as kind of a triple bottom line in the sense that you're doing the thing that I went to law school to do and wasn't sure I would ever get the opportunity to do, honestly, because there aren't that many opportunities to do these cases. Secondly, you can actually get paid for doing it. And thirdly, you can continue to learn and grow while you're doing it because it has that meretricious cycle. So I think it's a huge career builder to do work like this. I think it's tremendously, certainly the most rewarding work that I do. Josh talked about, there are clients, this is Rhode Island, right? So I go to Stop and Shop and I see clients 40 years later in whose matter I did not prevail, who come up and hug me because I treated them with respect and dignity. I really gave a shit and fought as hard as I could. I've had opposing counsel refer to me, greatest compliment I ever received, as like a tick on a dog, greatest compliment I ever received. And if someone sees you embodying that on their behalf, win, lose, or draw, it is meaningful. And so, that's what really keeps me coming back every day, is to continue to have those experiences. And this is one of the only actual mechanisms in Rhode Island where you can have the court officially appoint you a mentor. When I get called now, sometimes I ask for co-counsel to be appointed because these are hard cases. It's hard to figure it out all on your own, and you might be on vacation one day. So you might need someone to back you up. So I think that it's such a meaningful platform through which to learn and grow in this field that I can't think of a good reason to not take an appointment. And you do have the choice. I wanted to also mention that, just the logistics of this work. You will be contacted, you would be offered the opportunity to serve, which I have to say, I got a call from Judge Sullivan. I was flattered, it was like, well, I'd like to try and do that. But then you have to meet with the client, learn about the case, find out whether you would be able to be effective, even with help, and whether you have the room in your practice to take it on at that time. And then once you've met with the client and understand the pleadings and where the case is at, that's when you make the decision. It's not like you're going to get a cold call and yay or nay before investigating the circumstances of the case and whether it's a good fit for you, given what else you have on your plate at that time. So I really think that it's important to know that it's not scary. You get that call, you should look into it. And then if you need help or want to be appointed in a certain manner, I've received conditional appointments and appointments of limited scope. So if there is a part of the claim that you want to dig into and represent the pro se litigant in, sometimes you can also do that and carve out something that is not going to be a part of the case that you can meaningfully address. So there's a lot that goes into that process. It's not just that you're going to get a phone call and you have to say yes or no.
Can I just
Barbara,
add one
yeah.
quick thing? On cost particularly, if you do accept an appointment, one of the terrific aspects of this court is there's a lot of hands-on case management by our judges and magistrate judges. So you will have the opportunity to raise concerns and realities I mean, we can't lose sight of Rule 1. It's the driving force in litigation, just, inexpensive, and speedy pursuit of justice, whatever it says particularly. But you will meet with a judge at a Rule 16 conference. You are obligated to meet and confer. Our court has a process if discovery disputes arise where you can write letters to the judge or the magistrate judge to ask for a conference. And just be candid about the realities of your case and your situation, accepting one of these cases if you're up against a big bad defense lawyer from a national law firm, right? To just say, these are some of the constraints I have, Your Honor. And you know what's going to happen? The judge is going to look at me and say, well, Stephen, what's the problem? Why aren't you cooperating? So you're absolutely right. Cost can be a driver and an issue, and economics are part of the reality of practicing law. But throughout the case in this jurisdiction, our judges want to know what's going on. You have the benefit of being assigned to a judge and a magistrate, and they are going to take a hands-on role to the extent that someone is being obstructionist and preventing you from doing your job, taking one of these appointments. And if costs are a concern, there are certain realities in any case as to what's needed and how much it will cost. But you do have the opportunity to proactively raise it with counsel, hopefully come to accommodations and understandings, or, if necessary, present it to the court. That's what the judges are here for. So, to answer your question, it's definitely a reality of these cases, and some firms want to know, well, how are we going to get paid and when? But if costs are becoming a concern as you're trying to do your job, just come to this building if the other side's not being accommodating.
I want to give a concrete example of that, if we're okay for another minute here. We did a case together. I was on the other side. We were on the opposite sides of a case. And it had to do with a group of employees and wages, and the dispute was over whether the correct wages were paid. And we were in a mediation context, and the court was very accommodating to our, very disenfranchised, low-income laborer clients. And really called upon the defense counsel and team to provide detailed records and do some detailed calculations. Defense counsel and the defendant could have tried to bury us under raw data that we would not have been able to parse. It was, hundreds of records, et cetera, and a small firm like ours would have struggled, honestly, to do that analysis. We would have gotten it done somehow. But the judge said, look, you have the personnel office working for the client that you represent. It's going to be incumbent upon the defendant to present that evidence in a form that everyone can understand it so that we can figure out what the right answer here is. And I really appreciated that, and there was not a lot of pushback from the employer or from the employer's representative, the gentleman sitting to my left, because instead of bickering about what the numbers were, we got to the legal issues underlying as to what the rights were and whether or not the proper thing had been done vis-a-vis those wages, and we were able to come to a solution. There's another version of that story that I think anyone who's done litigation and discovery could tell. And that is the good version of that story. And it really got us to a result that was much more substantive than hiding the ball. So I will say that that's an important factor. And this courthouse will cause the litigants to do the better version of that, in my experience, almost universally. Barbara, was there anything else you wanted to do to exhort this crowd to definitely sign up?
No, can you just very, very quickly give some examples of cases where we would point to counsel?
Sure. So our office has done a fair amount of work in the area of solitary confinement, and particularly as it relates to persons experiencing mental illness. And, I always find that to be a pretty wild sentence, that you should not put people who are already mentally ill in long-term solitary confinement. The practices in Rhode Island, I'm happy to say, have largely changed dramatically in recent years, such that is much less a factor now. It's not entirely resolved, but there's been a tremendous amount of progress in that domain. And 5-6 years ago, the first time Judge Sullivan called me in my current capacity was to take on the case of one of my favorite people, a very hilarious and dogged and committed pro se litigant who just never met the word, would take a no for an answer, who I worked with over the last 6 years relating to claims relating to extended solitary confinement for someone who had a previously diagnosed mental health condition. And that person is currently not incarcerated, and I'm happy to say we meet from time to time, and that person is doing very well and continues to come and explain to me exactly how I should run my life whenever he sees me, and has lots of ideas and opinions. And it has really been enriching to my life to know this individual. And this is someone who was described in records as largely functionally illiterate and cognitively impaired, and I can assure you this person is neither. And in fact, one of the things I was most salty about in handling this case is that at one point we were dealing with a whole bunch of complex questions in the solitary confinement matter for this, at that time, incarcerated individual, and he had brought another case, of course, on his own behalf. And Judge Sullivan said that he did a better job representing himself in that matter than we were doing in the case in which she had appointed us. I was like, really? Did you have to go there? That was not kind. But I think it was accurate. So you really learn a lot from doing these cases. That's my favorite example at the moment.
Thank you. Information about the pro bono panel is on the court's website. If you're interested in that, nothing you have done by coming to these sessions has committed you to do anything. If you're interested in just more information about it, call me, call the clerk's office and ask for me, or Mike Simoncelli, or Megan Kenny, or anybody involved in the first aid program. And that's it. Look for something from us next week.
Great job, everyone.
Thanks so much.
Great job.
We certainly do. Remember when we spoke months ago? One scenario in which we might actually have to put something on the record. Yeah, I think so. Yeah.
And you know our firm has been tag team. Oh, good.
So great.
What participation on this? But
He's enriching